jurisdiction, and organization. Before we can understand how our court system is organized, we need to understand the basics of jurisdiction. Jurisdiction is the authority to administer justice. In the case of the courts, this is the power to hear a case and provide a remedy. There are three main sources of jurisdiction in our common law system. The first type of jurisdiction is in subjectum jurisdiction, or jurisdiction over the subject matter. Courts must have subject matter jurisdiction over the issue in the case. Because bankruptcy is part of the federal code, it falls within the federal jurisdiction. Congress created a separate set of limited jurisdiction courts to deal with this part of the code, and so these are the courts with subject matter jurisdiction over bankruptcies. Jurisdiction over criminal matters is a little trickier. Some limited jurisdiction state trial courts will have jurisdiction over minor crimes like misdemeanors, while major state trial courts would have jurisdiction over serious felonies like murder. But the federal courts may also have jurisdiction over murder. In this situation, it might matter where the murder takes place. This takes us to our second type of jurisdiction, which is in locum jurisdiction, or jurisdiction over the territory. This means that the court has jurisdiction over a particular geographic area. Here is a map of our state court districts. This means if you commit a felony in Clark County, you'll be headed to the Clark County District Court over at the Regional Justice Center. But your pretrial hearing may happen in a justice court in one of the cities if that's where the crime was committed. So, if you commit a felony in Henderson, you'll have your pretrial hearings at the Henderson Justice Court before heading off to the Clark County District Court for trial. Another example of the importance of territorial jurisdiction is the case of John Allen Muhammad, the D.C. sniper. He committed murders in several states and in the District of Columbia. He was tried and convicted in both Virginia and Maryland. The federal government and the remaining state governments declined to prosecute him after this, mainly because he'd already received the death penalty in Virginia and 6 consecutive life sentences in Maryland. He has since been executed. The final type of jurisdiction is in personam jurisdiction, or jurisdiction over the person. Courts typically have personal jurisdiction over the people who reside or are physically present in the state. So, say that you travel to the Northeast, and on your travels you come across a lovely little antique store. The proprietor sells you a priceless artifact from the Revolutionary War. Thrilled, you head back to Nevada with George Washington's musket. It only costs you $50,000. Itching to gloat on national television, you head down to the gold and silver pawn shop. There, Chum Lee informs you that this is actually a virtually useless replica. You've been had, and you're angry. You head down to the Clark County District Court to file a lawsuit against the antique shop. But wait, the antique shop is in Massachusetts. The Nevada court doesn't have personal jurisdiction over the shop. This means that you'll have to file a lawsuit in Massachusetts. You wouldn't be able to sue in the federal courts because those courts have a minimum dollar amount of $75,000 for diversity jurisdiction to kick in. Now, we know what jurisdiction is, and we know the major sources of jurisdiction. Next, it's time to see how jurisdiction is directly related to the organization of our court system. On the left are the courts with federal jurisdiction. The federal jurisdiction started out relatively small, but has grown substantially over the years. Cases are in the federal jurisdiction if they concern matters of federal law or if the parties to the lawsuit are from different states. On the right, we have state jurisdiction. each state has its own court system, and each one is different. But what we see here is the typical setup of a state court system. State courts have jurisdiction over their own geographic area and over issues of state law. Notice that this chart does not put the state courts as subordinate to the federal courts, even though the Constitution requires that state courts abide by the federal Constitution. These are truly parallel systems. So the distinction between federal and state jurisdiction forms the horizontal framework of the court system. But the courts are also organized vertically. The bottom level of courts has original jurisdiction. These are trial courts. In the trial courts, matters of fact and law are litigated. The judge always decides the matters of law, but there is usually a jury to make determinations of fact. The top two levels of courts are the appellate courts. Unlike trial courts, appellate courts make determinations on matters of law, but not on facts. There aren't juries here, and the judges usually sit in panels. This means that there are several judges hearing each case as a team. There is no testimony provided, although the lawyers may show up in court to present legal arguments to the judges. Another source of the vertical structure is the power of the court to set its own agenda. The bottom two layers of the judiciary have what is called mandatory jurisdiction. This means that the court must make a decision about the cases that come before it. This also means that trial court judges must make some sort of determination on the merits of each case. Notice that trial courts and intermediate appellate courts both have mandatory jurisdiction. This means that litigants who lose at trial have a right to appeal to the intermediate court. The court may dismiss the case on the merits, but it cannot simply decline to decide. But courts in the highest level of the judiciary do get to decide which cases to hear. This is called discretionary jurisdiction. This means that litigants must ask or petition the court to consider their appeals. And, by extension, it means that these courts may deny the opportunity to appeal. The U.S. Supreme Court has a completely discretionary docket. The case isn't so clear-cut when it comes to the state Supreme Courts. We'll talk more about that later on. In the meantime, suffice it to say that most state Supreme Courts have a substantially discretionary jurisdiction. So, when we consider all of these types of jurisdiction at the same time, you can see how jurisdiction creates the structure of our court system. Each of the types of courts has a different combination of these types of jurisdiction, and this allows us to place them in the correct spot on the hierarchy. For the federal court system, cases start here in the federal district court. There is an appeal as of right to the Court of Appeal, such that the Court of Appeal must decide who should win on appeal. From there, unhappy litigants may petition the U.S. Supreme Court to consider their appeal. But because the Supreme Court has discretionary jurisdiction, the court may decline to rule on the case. In fact, this is what happens to most petitions to the Supreme Court. Cases in the state court systems start in the trial courts. They are appealed to the intermediate appellate courts in those states that have them. Thanks to a successful 2014 amendment to the Nevada Constitution, we have one of these now. From here, litigants may appeal to the state Supreme Court, which may or may not take the case. This depends a lot on the merits of the case and the degree to which the state Supreme Court has discretionary jurisdiction. In the state court system, though, there is one final avenue for appeal, which is to the United States Supreme Court. But this bridge from the state court system to the federal court system is only available in cases where there is a federal question at stake. The Supreme Court will refuse to hear cases from the state courts if they have no federal questions involved, or if the state court had what is called independent and adequate state grounds for making the decision. These jurisdictional distinctions form the structure of our court system.